Good morning. This is Judge Netcher. We're here on initial appearances in Osceola County. We require a Spanish interpreter, and I will swear you in. Are you ready?
Yes, Your Honor.
Okay. Do you solemnly swear or affirm that you will faithfully translate from English to Spanish and Spanish to English to the best of your ability, so help you God?
I do. Alan Figueroa, State Certified Spanish Code Interpreter.
Okay. Mr. Cruz Diaz, I am appointing the public defender to represent you this morning.
Señor Cruz Díaz, se le designará la oficina de defensor público para que lo represente esta mañana.
You are here on a charge of battery, touching, or striking.
Se encuentra acá ante un cargo de agresión física.
I have reviewed the arrest affidavit and determined that there is probable cause for the charge.
He leído la affidavit de arresto y determino que existen indicios de criminalidad para el arresto.
The court will set bond at $1,000.
Se fijará la fianza en $1,000.
As a condition of bond, sir, you are not to have any contact with the alleged victim.
Como condición de la libertad bajo fianza, señor, se le prohíbe el contacto con la supuesta víctima.
Anything further from the state?
No, Your
¿Algo
Honor.
más de parte de la fiscalía? No, su señoría.
Defense?
If we could have a one-time return with law enforcement, Your Honor?
Defensa, si se le permite regresar una vez con las autoridades, su señoría.
The court will permit a one-time return to the location under the supervision of law enforcement to recover any personal belongings.
Se le permitirá regresar una vez junto a las autoridades para recoger sus pertenencias.
Thank you, sir. Best of luck to you.
Your Honor,
Gracias,
will
señor.
that
Buena
be
suerte.
with PTO?
Su señoría, ¿eso será con condiciones de libertad provisional?
He qualifies?
Yes, Your
Reúne
Honor,
los
for a
requisitos.
bond with PTO.
Sí, su señoría, para fianza con libertad provisional.
Yes, with PTR.
Sí, con condiciones de libertad provisional.
Thank you, sir.
Gracias, señor.
Okay, who else do we have in terms of Spanish interpreters, Ms. Smith?
The next one is Ivan Melendez Alicia.
Okay, good morning, sir. I am appointing the public defender to represent you.
Buenos días, señor. Se designará defensor público para que lo represente.
You are here on a charge of driving while license suspended.
Se encuentra acá ante un cargo de conducir con licencia suspendida.
Do you need a second state?
I'm sorry, what was the defendant's name?
Okay, this is Ivan Melendez Alicia. We skipped through because we're getting the Spanish interpreter
Right,
cases.
I have him as charged with possession, not.
There are two charges on that one. One is the duelist, and then the other one is possession.
Son dos cargos, su señoría. Uno es por tenencia y el otro por conducir con la licencia suspendida.
That's correct. There's two separate cases. And I'm addressing the driving while license.
Got
It's been a first.
I'm on the same page now, I apologize.
No worries.
Correcto, son dos casos. Estamos viendo primero el de conducir con licencia suspendida.
The court has reviewed the affidavit and determined that there is probable cause for the charge.
Se ha leído la affidavit y determinó que existe indicio de criminalidad para el cargo.
The court will set bond on the driving while license suspended count at $250.
Se fijará la fianza en el cargo de conducir con licencia suspendida en $250.
You are also here, sir, on charges of possession of cocaine and possession of drug paraphernalia.
Señor, también se encuentra acá ante un cargo de tenencia de cocaína y de tenencia de adminículos de droga.
The court has reviewed the arrest affidavit and determined that there are probable cause for those charges.
Se ha leído la affidavit de arresto y determinó que existe indicio de criminalidad para esos cargos.
Court will set bond on the possession count at $2,000
Se fijarán $2,000 de fianza ante el cargo de tenencia
and on the drug paraphernalia count at $250.
y $250 ante el cargo de los adminículos de droga.
As a condition of any release under bond, sir, you are not to have any drugs or non-prescription medications.
Como condición de su libertad bajo fianza, señor, se le prohíbe el uso o tenencia de ningún tipo de droga o de ningún medicamento sin receta.
Anything further from the state with respect to Melendez
¿Algo más de parte de la fiscalía?
Alicia?
No, Your Honor.
No, su señoría.
Nothing, Your Honor.
Okay.
Nada más.
Thank you, sir.
Gracias, señor.
Who is our last Spanish interpreter?
Apologies, there are two more. The first one is Sebastian Dominguez. And he is present and approaching.
Last one. Good morning, sir. I am appointing the public defender to represent you.
Buenos días, señor. Se le designará el defensor público para que lo represente.
You are here on a charge of battery by an inmate.
Se encuentra acá ante un cargo de agresión física por un reo.
I have reviewed the affidavit and determined that there is probable cause for the charge.
He leído la affidavit y determino que existen indicios de criminalidad.
Court will set bond at $1,500.
Se fijará la fianza en $1,500.
Anything further from the state?
¿Algo más de parte de la fiscalía?
No, Your Honor.
No, su
Defense?
señoría. ¿Defensa?
No, Your Honor.
Okay, thank you.
No, su señoría. Gracias.
And our next Spanish interpreter case?
It is Raquel Mora Leon.
Okay. Raquel Mora Leon. Good morning, sir. I am appointing the public defender to represent you.
Buenos días. Se le designará a la oficina de defensor público para que lo represente.
You're here on a charge of battery by an inmate.
Se encuentra acá ante un cargo de agresión física por un reo.
Court has reviewed the affidavit and determined that there is probable cause.
He leído la affidavit y determino que existe indicios de criminalidad.
Court will set bond at $1,500.
Se fijará la fianza en $1,500.
Anything further from the state?
No, Your Honor.
¿Algo más de parte de la fiscalía? No, su señoría.
Defense?
No, Your Honor.
Okay,
Defensa,
thank you, sir.
No, su señoría. Bien, gracias, señor.
And one more Spanish interpreter, Ms. Smith?
No, Your Honor, that was it.
Okay. Mr. Interpreter, thank you for your time. Happy New Year.
Happy New Year, Your Honor. And Your Honor, just to make sure so that the interpreter stays waiting, you will call back for the orange cases?
Correct.
Thank you.
Thank you.
Oh, what just happened?
Okay, sorry about that. Diana Gonzalez.
Your Honor, she is no longer in the jail.
Okay, she bonded or?
Yes, Your Honor.
Okay, thank you. Jennifer Goodman.
She has also, was she transferred? She is also bonded out, Your Honor.
Okay, thank you. Alan Goris.
He's present and approaching, Your Honor.
I'll get rid of the screen. Good morning, sir. I am appointing the public defender to represent you. You are here on a charge of child abuse without great bodily harm. The court has reviewed the affidavit and determined that there is probable cause for the charge. Court will set bond at $2,500. Does the victim and the defendant reside together?
They are, Your Honor. We will be asking for a one-time return with law enforcement.
Okay, thank you. As a condition of release, you're not to have any contact with the alleged victim, and you're to maintain separate residences. The court will permit a one-time return to the location to recover any personal belongings that you have under the supervision of law enforcement. Anything further from the state?
No, Your Honor.
Defense?
No, Your Honor.
Okay, thank you. Best of luck, sir. Daniel Hearns.
He is present and approaching, Your Honor.
Good afternoon, morning, sir. I am appointing the public defender to represent you.
Good morning, Your Honor.
You are here, sir, on a failure to appear on a written promise charge. Bond was set at $2,000. Court will set it at $2,000. I believe you also have another.
Your Honor, the second charge of the petty theft, $100 to $300. The jail is in the process of unarresting him on this.
Okay. I did have some probable cause questions, but So is this state? Do you have any representations on the second charge for petty theft?
No, Your Honor. The state will leave it to the court's discretion.
Okay. Could you help me out with that, Ms. Smith? What they're unarresting him?
PTR came in earlier and told me that they are, I guess, dropping that.
Yeah.
Okay. I see that. I see that now, and so the court will ROR him on that. Take no action. Thank you. William Jaski.
Jasky?
Jasky.
Yes, he is present and approaching, Your Honor.
Your Honor, he does qualify for a bond with PTO.
Okay, thank you. Okay, sir, I'm appointing the public defender to represent you. You're here on a charge of battery. I've reviewed the affidavit and determined that there is probable cause for the charge. The court will order PTR with a bond of $250. As a condition of the release, sir, you're not to have any contact with the alleged victim. Do they reside together?
Yes, Your Honor. He will need a one-time return.
Okay, the court will permit a one-time return to the residence to recover any personal belongings under the supervision of law enforcement. Anything further from the state?
Did you list the condition of maintain separate residence?
Thank you. And also as a condition, sir, you have to maintain separate residences. Anything further from the defense?
Nothing from defense, Your Honor.
Okay, thank you. Sebastian Ortolaza.
He is present and approaching, Your Honor.
Your Honor, he qualifies for a bond with PTO.
Thank you. Good morning, sir. I am appointing the public defenders to the lawyer standing next to you to represent you this morning. You are here, sir, on two charges: one battery and one count aggravated battery with a deadly weapon. The court has reviewed the affidavit and determined that there is probable cause for both charges. The court will set bond on the battery count at $500, on the aggravated battery count at $3,500. As a condition of release, sir, you're not to have any contact with the alleged victim. There are multiple victims in this case. You have to have contact with any alleged victim, and you are not to return to the scene of the alleged crime. Anything further from the state?
No, Your Honor.
Defense?
We will be asking for a one-time return to his home with law enforcement, Your Honor.
Did he live there? I was under the impression
One
that
of the victims, one of the alleged victims is he's in a romantic relationship. They reside together.
okay, and she has items of his. Is that
Yes, Your Honor.
okay? The court will permit a one-time return under the supervision of law enforcement. Thank you.
Your Honor, is that with PTR or without?
With PTR, thank you. Sorry about that. Michael Rodriguez.
Your Honor, he is present and approaching, and there is a probable cause argument.
Okay. Good morning, sir. I am appointing the public defender to represent you this morning. Ms. Smith, you have a probable cause argument?
Yes, Your Honor. Per the Florida statute 784.04, a person commits a felony battery when they actually and intentionally touch or strike another person against the will and cause great bodily harm, permanent disability, or permanent disfigurement. It merely says within the charging affidavit that she had a small cut on the side of her face and that she was bleeding from. I don't think that rises to the standard of great bodily harm, permanent disability, or permanent disfigurement. In fact, in the affidavit, the officer says that he caused the victim disfigurement, but that would need to be permanent disfigurement.
State response.
Your Honor, could the state have a 24-hour reset to contact the officer?
I'm inclined to grant the 24-hour reset. Ms. Smith, do you have any?
Your Honor, we object. The defense will object to the 24-hour reset because the officer did take the time to say that, that these things are what he believes would rise this to the level of a felony battery. And if he intended to put something more in the charging affidavit, he would have done so.
I think Ms. Smith might be right in terms of the charge being wrong. If there's a different charge, then I think the state can raise that. So I am going to ROR him on count one, committing felony battery based on a determination of no probable cause.
Thank you, Your Honor.
Thank you.
Thank you.
No PC. No PC.
Oh,
ROR. No. London Spanks? Spunks?
Landon Sparks, Your Honor. He is present
Sparks.
and approaching.
I apologize. That's.
We're not going to do that. Get up.
Good.
My apologies, Your Honor.
It's okay. Good morning, afternoon, sir. I'm sorry, Ms. Smith. If you could mute yourself when you're not speaking.
Yes, Your
Thank you. Getting some feedback from you. Mr. Sparks, the court is appointing the public defender to represent you. You're here on a charge of trespassing. After warning, the court's reviewed the affidavit and determined that there is probable cause for the charge. Court will set bond at $250 with a condition of no return to the scene. I understand there's an open case and case number. I don't have a case number, but there's an open case. I'm not going to take any action on that today.
Thank you, Your Honor. Would Your Honor consider a non-monetary bond in this action? Mr. Sparks is homeless, and $250 would be bond would be an insurmountable amount for him to.
I got all my stuff under the bridge by Walmart. I'm gonna lose everything.
State any position on the.
State wouldn't object to an ROR.
Okay. The court will ROR them with the condition of no return. Sir, it's critical that you show up for your court appointments. Do you understand that?
Yes, sir. Can you tell me am I getting ROR today?
Yes, sir, that's what the court is doing.
Can I get both of my
Thank you, Your Honor.
Thank you. Okay, Alexis Stevens.
She is present and approaching, Your Honor.
Your Honor, she qualifies for a bond with PTR.
Thank you. Good afternoon, Ms. Stevens. I am appointing the public defender to represent you.
Yes,
You are here on 2 counts. 1 count, false imprisonment against the victim's will, and an account of assault, aggravated assault with a deadly weapon. Court has reviewed the affidavit and determined that there is probable cause for both charges. Court is going to set bond on the false imprisonment count at $500, on the assault, aggravated assault count at $2,500.
thank you, Your Honor.
As a condition of release, you are not to have any contact with the alleged victim. Do you understand? No contact means no contact whatsoever. No text messages, no emails, no phone calls. Do you understand that?
Yes, Your Honor, I understand.
Okay. Do they reside together?
Yes, Your Honor. She will need a one-time return.
No,
Okay.
I actually don't live with him. Sorry.
So Ms. Smith, no one-time return, or
You don't need it, you don't have anything there? Okay, she's let me know that she doesn't have anything there, Your Honor.
okay? Okay. Anything further from the state?
Is there a third charge that I see written in?
I only have. Is there a third charge, Ms. Smith?
I have the third charge of dating violence, of 74.046, written in. However, there would be a probable cause argument on that.
I'm a little confused about that charge, anyways, because as I understand it, that's the civil injunction statute. Is there a specific criminal offense for dating violence that I'm not aware of?
The charge under 784.046 is action by victim of repeat violence, sexual violence, or dating violence for protective injunctions that is within the Florida criminal statute section, but
It's weird, though, because the statute itself just creates a cause of action for civil injunction.
yes, Your Honor.
I mean, state, can you point me to somewhere where there's a specific criminal prohibition? Obviously, if there's violence, that's prohibited under other statutes, but a criminal prohibition on dating violence, I don't know that I've seen that.
The state would ask for a 24-hour reset to just be able to contact the officer for any information they may have left out.
Okay, I'm going to ROR on the dating violence count to the extent that it's part of this case. I don't know that it is. It's handwritten in. I'm not sure that it may be a modifier to the aggravated assault,
Okay.
but I'm not sure. So if to the extent that it's a count, I'm going to ROR on it.
Thank you, Your Honor.
Okay. Anything further from the state?
No, Your Honor.
Your Honor, would that be with PTR or without?
With PTR. Eric Swain.
Your Honor, if we could bring him up last.
Sure.
Thank you.
Brady Wayne Suzuki.
He is present and approaching, Your Honor. He also qualifies for direct PTR.
Good afternoon, sir. I'm appointing the public defender to represent you. You're here on a charge of operating a motor vehicle without a license and no motor vehicle registration. Court has reviewed the affidavit and determined that there is probable cause. Court will order direct PTR with no bond.
Thank you, Your Honor.
Thank you. Catherine Thayer.
She is present and approaching, Your Honor.
Good afternoon, ma'am.
With PTR.
I'm sorry, say that again, sir.
She qualifies for a bond with PTR.
Thank you. Ma'am, I'm appointing the public defender to represent you today. You are here on a charge of battery. Court has reviewed the affidavit and determined that there is probable cause. Court will set bond at $500. Do they reside together, the victim and the defendant?
Yes, Your Honor. She will need a one-time return.
Okay, as a condition of your bond, ma'am, you are to not have any contact with the alleged victim and to maintain separate residences. The court will permit a one-time return to the location to recover any personal belongings. Also, as a condition of your release, you are not to have any alcohol. You understand that?
Yes.
Okay. Anything further from the state?
No, Your Honor, and this is a PTR with bond.
Correct. PTR with bond. Defense?
Nothing from defense, Your Honor.
Thank you. And the last case I have is Mr. Swain. Do we have any others?
No, Your Honor. This is our last case.
Okay, Eric Dwayne Swain.
And there is a PC argument on this case.
Okay.
Regarding the second charge of carrying.
Just a second. We'll get there.
Yes, Your Honor.
Good afternoon, sir. I am appointing the public defender to represent you. You are here on charges of false identification to law enforcement officer, count 2 of carrying an unregistered concealed firearm, count 3 of child abuse, simple neglect, and count 4 disorderly conduct. I understand there's a probable cause argument.
Yes, Your Honor. Regarding charge 2 of the carrying a concealed firearm, per the statute 790.012, a concealed firearm means any firearm which is carried on or about the person as to conceal the firearm from the ordinary sight of the person. However, within the charging affidavit, it says that the firearm was in the glove compartment, and then further in the charging affidavit, it said that it was not secured within that he was charged with the carrying the concealed firearm because it was not secured in the glove compartment. And I don't believe that having a firearm within the glove compartment counts as being in or on their person, especially at the time he was detained. He was outside of the vehicle and never went back into the vehicle after the, at least from what the narrative says, from the time the officer came on scene.
Any response from the state?
Just one moment, Your Honor.
Sure.
State has no objection to or no response to the PC argument.
Okay. Okay, the court will conclude that we'll find no probable cause on count 2, and he'll be ROR'd on count 2. As to the other counts, false identification of law enforcement, child abuse, and disorderly conduct, the court concludes that there is probable cause based off of the affidavit for the arrest. Court will set bond on count 1 at $250. On count 3 at $2,000. And on count 4 at $250. As a condition of release, sir, you're not to have any contact with the individuals that were involved in this alleged incident. I think it was someone was followed to, and so you're not to have any contact with that person or to return to the scene of where you went. Anything further from the state?
No, Your Honor.
Defense?
No, Your Honor.
Okay, thank you, sir. Best of luck.
Thank you.
Okay, is that all in Osceola County?
Yes, Your Honor. Have a great day.
You as well. Happy New Year, and we'll see you soon.
Yes, sir.
Good morning, Your Honor. Alan Figueroa, State Certified Spanish Code Interpreter, back on the line.
Good morning. Okay, we're ready to go. We have 3 Orange County cases that require interpreters, so we're going to proceed. Okay, Lesdemi Crisana Danny Luke Torres. Good afternoon, ma'am. I am appointing. I'm sorry. Okay,
They haven't worked for the last 2 days.
so she'll listen in over the speaker.
Yeah, no, she also had a victim, but they didn't bring it up.
They did not bring her up.
No, we just called them to bring it up, but they didn't hear it.
Okay, do we want to take this?
Let's take a brief recess until the victims have been brought up, please.
Yes, we'll take a brief
We'll
recess
get it in a minute.
until the victims are
Supposed to be
brought
here
up.
already, but
Thank you, Your Honor.
If we want to go to the next case, can we do that?
and then the next page here.
Pedro Hernandez. Okay, good afternoon, sir. I'm appointing the
Buenas
public,
tardes, señor.
I'm appointing the public defender to represent you.
Se le asignará defensor público para que lo represente.
You are here on charges of battery, domestic in nature.
Se encuentra acá por cargos de violencia doméstica, agresión física.
The court has reviewed the arrest affidavit and determined that there is probable cause for the arrest.
Se ha leído el affidavit de arresto, determinó que existe indicio de criminalidad para el cargo.
Court will set bond at $500.
Se fijará la fianza en $500.
Do they reside together?
¿Viven juntos?
Sir, do you reside with the alleged victim?
¿Usted vive junto con la supuesta víctima, señor?
Con mis hijos y mi hija, son ellos mis hijos, mis niños. Yo vivo junto con ellos.
With my son and my daughter, they're my children. I live with them.
And we don't have any victims or anybody here present. Is that right?
No tenemos ninguna víctima, ningún testigo presente, ¿correcto?
At this time, the court's going to order no contact with the alleged victim.
En estos momentos se le prohíbe el contacto con la supuesta víctima.
separate residences,
Debe buscarse otro paradero
and no alcohol.
y cero consumo de alcohol.
Okay, anything further from the state?
¿Algo más, Fiscalía?
The state just wants to clarify that the children have a guardian.
Do the children?
La Fiscalía quisiera asegurarse que hay alguien que pueda cuidar a los niños.
Do the children live with the mother or somebody else?
Mi hermana.
¿Los niños viven con una madre o con alguien más?
Ah, ahorita, ayer que yo me vine, quedó con un tío. Pero
Ah,
me gustaría que los cuidara mi hermana.
Yesterday that I got here, they stayed with an uncle, but I would like for them to stay with my sister.
Is that an appropriate resolution to that concern, state
Yes, Your Honor.
defense?
¿Le parece bien esa solución? Fiscalía, sí, su señoría. ¿Defensa?
The defense can't object to that because it's not something that can be ruled upon in this court. So considering that this is the father, we are going to need a return, and he'll have to deal with the custody situation through family court.
Dado que no se puede tomar esa decisión en este momento en esta sala, quisiéramos pedir que se le permita regresar una vez y que el tema de la custodia sea resuelto a través del juzgado de familia.
Okay. Thank you, sir.
Gracias, señor.
¿Cómo puedo?
Sorry. I'm sorry, does he need a one-time return?
Yes.
Okay, court will allow a one-time return under the supervision of law enforcement.
Thank you.
Se le permitirá regresar una vez junto a las autoridades.
It's a one-time return.
Oh, yeah. Okay, is the witness present for this one? Okay, Lesbny Crisana Danny Luke Torres. Good afternoon, ma'am.
Buenas tardes, señora.
I am appointing the public defender to represent you.
Se le designará al defensor público para que la represente.
You are here on a charge of battery.
Se encuentra acá ante un cargo de agresión física.
The court has reviewed the charging affidavit and determined that there is probable cause for the charge.
He leído el affidavit y determino que existe indicio de criminalidad para el cargo.
And we have a witness present. Sir, can you state your name?
Y tenemos un testigo. Señor, diga su nombre.
Jesús Roa.
Could you please take the mask off and speak a little clearer so the interpreter can hear you?
¿Se puede quitar la máscara, por favor, y hablar un poco más claro?
Jesús Roa.
Jesús Roa.
Sir, do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Señor, ¿jura o promete que el testimonio que rendirá será la verdad, solo la verdad y nada más que la verdad? ¿Lo jura ante Dios?
Lo juro.
I do.
Sir, are you the alleged victim in this case?
¿Es usted la supuesta víctima en este caso, señor?
Sí, señor.
Yes, sir.
If the defendant is released, do you wish to have any contact with her?
Si ella quedara en libertad, ¿usted quisiera tener contacto con ella?
Sí.
Yes.
Do you have any concern, would you have any concerns for your safety if the defendant is permitted to have interactions with you?
¿Tendría usted alguna preocupación con respecto a su seguridad si ella se le acercara?
No.
No.
Would you hesitate at all to contact law enforcement if there was another incident between the two of you?
¿Y dudaría usted en llamar a las autoridades si ocurre otro incidente entre ustedes como este?
Sí, señor.
Yes, sir.
What I'm trying to ask you is if, would you call law enforcement if there was an incident involving the two of you again?
Para aclarar, mi pregunta es, ¿llamaría usted a las autoridades si vuelve a ocurrir otro incidente entre ustedes?
Sí, señor.
Yes, sir.
Anything from the state with this
No, Your Honor.
defense?
¿Algo más de parte de la Fiscalía? No, su señoría. ¿Defensa?
No, Your Honor.
Court
No,
is
su
going
señoría.
to set bond at $500.
¿Se fijará la fianza en $500?
As a condition, ma'am, you are not to have any hostile contact with the alleged victim.
Como condición de la fianza, señora, se le prohíbe el contacto con hostilidad hacia el señor.
And You are also not to have any alcohol.
También se le prohíbe el consumo de alcohol.
Hostile. With PTR.
Con condiciones de libertad provisional.
And hostile contact means you can't as much as raise your voice at the alleged victim. You're allowed to have contact with him, you can interact with him, but you cannot have hostile contact, which could be a violation of the terms of your release.
Contacto sin hostilidad significa que no puede ni siquiera alzarle la voz a él. Puede tener contacto con él, puede comunicarse con él, pero ningún tipo de hostilidad.
Do you understand that?
¿Lo ha entendido?
Sí.
Yes.
Thank you, ma'am. Best of luck.
Gracias, señora. Buena suerte.
Thank you.
Florani Gabriela Otiero Perez. Good afternoon.
Buenas tardes, señora.
I am appointing the public defender to represent you.
Se le designará al defensor público para que lo represente.
You are here on a charge of battery.
Se encuentra acá ante un cargo de agresión física.
Court has reviewed the affidavit and determined that there is probable cause for the charge.
He leído el affidavit y determino que existe indicios de criminalidad para el cargo.
Court will set bond at $500
Se fijará la fianza en $500
with PTR.
con condiciones de libertad provisional.
Do they reside together? Do you reside with the alleged victim?
¿Ustedes viven juntos? ¿Usted y la supuesta víctima?
Sí, es mi esposo. Convivo,
Yes, my husband.
convivo con él hace 6 años.
I've been living with him for 6 years.
At this time, the court's going to order no contact with the alleged victim
Se emitirá una orden de prohibición de contacto con la víctima.
and maintain separate residences.
Debe buscarse otro paradero por separado.
Court will permit a one-time return to the location to recover any personal belongings.
Se le permitirá regresar una sola vez junto a las autoridades para recoger sus pertenencias.
Ok, muchas gracias.
Thank you, ma'am.
Ok, thank you.
Anything
Gracias,
further?
señora.
Your Honor,
¿Algo más?
I'd like to let her know that those conditions can be modified at a later time in front of the division judge.
Quiero dejarle saber a ella que esas condiciones pueden ser modificadas más adelante con el juez asignado al caso.
Gracias.
If you feel that you would like to have the conditions of your release modified, you can file a motion to that effect with the division judge.
Si usted desea modificar las condiciones de la libertad bajo fianza, puede radicar un pedimento ante el juez del caso.
With PTR. Okay, this is Creole. Are we done with Spanish? Mr. Interpreter, we are, I think, finished with your services. We'll let you know if anything else. Thank you.
Thank you, Your Honor.
Have a good one.
You as well.
I believe the next one, we need a Creole interpreter, so we're. Good afternoon, can you hear me?
Yes.
Are you our interpreter for Creole?
Yes.
Okay, I'll
My
swear.
name is Shirlene.
State your name, please?
My name is Shirlene, ID number 361504.
Thank you. Do you solemnly swear or affirm that you will faithfully translate from English to Creole and from Creole to English to the best of your ability, so help you God?
I do.
Okay. Basil Manuma. Good afternoon, sir. I am appointing the public defender to represent you.
Majuel Manouma, bon après-midi, messieurs. Moi, c'est yon défense publique yo désigné pour capable représenter ou.
Sir, can you hear the interpreter okay?
Messieurs, est-ce capable tendre interprète là bien?
Madam Interpreter, you're speaking a little low. We're having a little trouble hearing you in the courtroom. If you could speak up or get closer to the microphone, that would be helpful.
Is that better?
That's better, thank you. Okay, sir, you are here on 6 counts. 1 count, armed burglary of an occupied dwelling, a count of aggravated battery with a deadly weapon, 1 count of aggravated assault, 1 count of battery, 1 count of petty theft, and 1 count of aggravated assault with a motor vehicle. Court has reviewed the arrest affidavit and determined that there is probable cause for the charges.
Et monsieur ou là parce que yo chargé ou avec 6 différentes qualités charge, yon c'est ou al voler avec zam, deuxième nan c'est ou fait ou attaquer gravement, deuxième nan et yon l'autre encore c'est ou attaquer et l'autre là c'est ou battre yon moun, l'autre là encore ou attaquer pour font petit vol qui petit avec yon machine et puis tribunal là yo wè que gen cause qui probable.
Court will set bond on count 1, armed burglary of occupied dwelling, at $1,000. On count 2, aggravated battery with a deadly weapon, $7,500.
Et tribunal là y a fait caution pour ou dans premier compte à que ou attaqué gravement dans yon côté moun habité et kob là c'est $1,000, deuxième nan c'est ou attaqué avec yon zam qui capable menacer l'autre moun pour caution c'est $75,000.
Count 3, $2,000. Count 4, $1,000. Count 5, $250. Count 6, $1,000.
Troisième nan c'est $2,000, quatrième nan $4,000, cinquième nan $250, sixième nan $1,000.
As a condition of release, sir, you're not to have any contact with the alleged victim.
Et condition pour nous larguer ou se faut pas gen aucun contact avec victime supposée a.
And you are not to return to the scene.
Ou pas supposé retourner dans scène nan.
Sir, do you reside with the alleged victim?
Monsieur, est-ce qu'on habite avec victime, soi-disant victime nan?
Say it again.
Do you live
Est-ce
with...
que ou
Go ahead, Madam Interpreter.
habite avec sure. Est-ce qu'on habite avec soi-disant victime nan? Moun qui supposé victime nan?
Is that a no?
No.
Okay. The court will order no contact, no return to the scene, and anything further from the state?
Your Honor, could you repeat the bond amount for count 4,
Sure.
battery of domestic violence?
Count what, sorry?
Count 4.
Count 4 was $1,000.
Thank you.
Anything further from the defense?
Your Honor, we would just ask for a reduced bond on count 2. $7,500 is a lot of money. And when you total all of these up, he's looking at over $1,000 at the 10% surety bond.
Court's not inclined to do that. Thank you, though.
Thank you, Your Honor.
Thank you, sir. Best of luck.
Your Honor, can we ask a Madam Interpreter to tell him what I said?
Yeah, ma'am.
Hold on.
So- Madam Interpreter, if you could finish off the rest of the
Sure.
hearing for us.
Sure. Et juge là recommandé pour pas retourner dans scène nan pour pas gen aucun contact. Et avocat demandé dans compte fond c'est que combien kob yo charge yo $1,000 pour caution hein. Dans compte 2 a yo charge $75 pour caution hein. Et avocat a dit que et li trouve $75 trop parce que même les ou ta prend yon bel bond donc yon moun qui pour faire caution pour et à 10% ou a payer plus que $1,000 est-ce que il était capable de descendre ni et juge l'a dit non et ça lui dit arrêter.
Thank you.
You're welcome.
Thank you, Madam Interpreter. Have a wonderful day.
Thank you for using our services. You have a wonderful day.
So our next one on the list, we needed a sign language interpreter, but we don't have one yet, so we're gonna
Okay.
go to the next one. Jared Sean Kierstead. Good afternoon, sir.
Hello.
I am appointing the public defender to represent you. You're here on a charge of battery, domestic violence. Court has reviewed the arrest affidavit and determined that there is probable cause for the charge. Court will set bond at $1,000. As a condition, you're not to have any contact with the alleged victim. Do you understand that?
Yes, sir.
Do you reside with the alleged victim?
Yes, sir.
Okay, the court's going to order at this time separate residences, and I will permit a one-time return to the residence to recover any personal belongings under the supervision of law enforcement. Okay, anything further from the state?
No, Your Honor.
Defense?
No, Your Honor.
Thank you. Thank you, sir. Best of luck.
Well, I can't live there no more.
For right now, you just need to maintain separate residences. You can contact your attorney about modifying that agreement if that's available.
That's my mother's house, and I pay rent there. I put everything there at my mom's house.
Okay, well, one of you can't live there.
My stepdad or me.
If, sir, if you wish to alter or change the terms of your release, you can file a motion with your division judge.
I'm good. I'm gonna just leave home. I'm better off that way. I'm more happy that way.
Okay. Well, that's good to hear. Best of luck.
Stephen Richardson, mental health, Your Honor.
Okay. Could you say his name again? I still have John Doe on the list. Is it, what's his first name? Richardson?
Steven?
Richardson Stephen.
Okay, Stephen Richardson. I think this was a reset from yesterday. Do you want to reset again?
No, Your Honor. At this time, defense would like to waive the appearance of the defendant.
Okay. The court will appoint the public defender to represent Mr. Richardson. Counsel has waived the appearance of Mr. Richardson. He's been charged with trespass on property after warning. Court's reviewed the arrest affidavit and determined that there is probable cause. Bond will be set at $100 with no return to the scene.
Thank you, Your Honor.
Thank you. Mental health.
Mental health.
Anthony Irving Williams,
Refuse, Your Honor.
Your Honor.
reset or waive?
Waive.
Okay. So the court is appointing the public defender to represent Mr. Williams. Counsel has waived the appearance of Mr. Williams. Mr. Williams has been charged with 3 counts, 1 count possession of fentanyl, 1 count possession of drug paraphernalia, and 1 count resisting officer interference with law enforcement without violence. Court's reviewed the affidavit and determined that there is probable cause for the charge. Court will set bond on count 1 at $1,000, count 2, $250, count 3, $250. As a condition, he's not to have any drugs or non-prescription medications.
Thank you, Your Honor.
Thank you. Diamond Brunson. Good afternoon, ma'am. The court is appointing the public defender to represent you. You are here on a charge of an open container for alcoholic beverage. Court is inclined to ROR. Well, I've reviewed the affidavit and determined that there is probable cause. Court's inclined to ROR. State, do you have any objection to that?
No objection, Your Honor.
Okay. You'll be released on your own recognizance. It's critical that you show up for your court hearings. Do you understand that? If you do, you may, your ROR may be revoked and you could be put in jail. Thank you, ma'am. Best of luck.
Good luck to you, sir.
Freddie Lee Galloway. Good afternoon, sir. The court is appointing the public defender to represent you. You're here on a charge of disorderly conduct. Court has reviewed the affidavit and determined that there is probable cause for the charge. Court's inclined to ROR you, sir. State any objection?
No, Your Honor.
Okay. You'll be released on your own recognizance without bond, but it's critical that you show up for your court hearings. Do you understand that? Okay. Thank you, sir. Best of luck.
I'm not sure.
Your Honor, I seem to be out of order.
Yeah.
Okay.
I didn't,
Do you need a sec?
um,
Up next, we have David Wesley Scheibel.
Okay, that's where I'm at. I just didn't have Mr. Galloway.
I didn't either. I don't know what happened if he was supposed to be on a move up, but.
And I'm missing a Sebastian Fernandez.
I haven't seen that name yet.
Okay.
We'll go to David Wesley Scheibel.
Yes, Your Honor, thank you.
Good afternoon, sir. I'm appointing the public defender to represent you. You're here on a warrant arrest for violation of probation. Bond was set at $2,000. And it will stay at $2,000. Anything further from the state?
No, Your Honor.
Vince?
No, Your Honor, thank you.
Thank you, sir. Took that out of order. Christopher LeJean Burns. Good afternoon, sir.
Good afternoon.
I'm appointing the public defender to represent you.
Sir.
You're here on 2 counts, 1 count aggravated battery, and a count of domestic battery by strangulation. Court has reviewed the affidavit. Finds probable cause as to count 1. Do have a question on count 2 for counsel, and I don't want to open up a can of worms. The alleged victim was pregnant, is pregnant as I understand it, with the defendant's child. Does that, under the domestic violence statute for family or household members, does that change the calculus if the child hasn't been born?
I believe that aggravated battery on a pregnant person, count 1, but as to count 2.
It's a difficult question that I don't know the answer to, and I didn't know if anybody's given that any thought.
I think that it goes with domestic violence because they are expecting the child together.
Yeah, I'm gonna find probable cause on count 2. I just think,
It also says that they've been dating for approximately 2 years,
do they reside together?
and they do reside.
Okay, they reside together, that solves the problem.
Yes, Your Honor.
Court will find probable cause on counts 1 and 2. Court will set bond on the aggravated battery count. $3,000, and on the domestic battery count at $3,000. Sir, you're not to have any contact with the alleged victim. Do you understand that?
Sir.
You're to maintain separate residences from the alleged victim, and the court will permit a one-time return to the location under the supervision of law enforcement to recover any personal belongings.
Sir.
Anything further from the state?
No, Your Honor.
Defense? Is this
Nothing from the defense, Your Honor.
next case? Okay. Thank you, sir. Best of luck.
Thank you, Your Honor.
Nicholas Jean Charles Castell.
Yes, sir.
Good afternoon, sir.
Good afternoon.
I am appointing the public defender to represent you. You're here on a charge of contempt of court, violation of a no-contact order. I've reviewed the arrest affidavit and determined that there is probable cause for the charge. We have a witness present. Ma'am, can you state your name?
Nelson Mejia.
Okay, can you raise your right hand for me? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Okay. If Mr. Castell is released, do you wish to have any contact with him?
Yes.
Okay. Would you hesitate at all to contact law enforcement if there was an incident between the
No.
two of you? I'm sorry?
No.
Okay. Has something like this happened before?
No.
Do you have any concern whatsoever for your safety if you were permitted to have contact with the defendant?
No.
Okay. Court's going to set bond at $1,000. The defendant is not to have any hostile contact with the alleged victim, and of course to follow the injunction order that is already in place. No, it'll be no hostile contact on this case, but there's an injunction order in place, as I understand it. Correct?
Yes, Your Honor, and there's also,
Another case.
a battery with the same victim.
Is it the same victim? That was my question. Okay. Okay. So I'm going to order no contact with the alleged victim. No contact whatsoever, no hostile contact. So follow your injunction that's been entered. No contact with the alleged victim. There's also, as an open case, case number 2021 MM 9132. State have a position on that?
State would request that bond be revoked in that case.
Defense?
Your Honor, considering that the alleged victim is here in court today and she's wanting contact with him, I think that this is going to turn out to be more than it was actually happened. And so I would ask that you not revoke bond because she clearly doesn't have an issue with having contact with him. This is just something that needs to be cleared up in the courts, probably with the declination. I would like to inquire of the witness, if I may.
You may.
Ma'am, are you the alleged victim in the underlying case?
Yes.
Do you have any fear of Mr. Castell?
No.
Are you afraid that this is going to happen again?
No.
Has it ever happened before?
No.
And you testified a moment ago to the judge that you would like to continue having contact with Mr. Castell. Is that correct?
Yes.
Okay. Your Honor, I have no further questions of the witness at this time.
State, any questions?
Your Honor, I have no questions for the victim, but I would just like to point out that the previous case happened December 25th, a very short time ago, and just in the interest of the victim, we request that bond be revoked in that case.
Okay. And did you have something else to add?
Yeah, I just want to know if I want to drop the charges.
Okay. That's not, we're not here to do that today, but the court is going to revoke bond.
May I respond, Judge?
You may.
Your Honor, the state is claiming to be acting on the best interests of the victim, and the victim is testifying to the contrary.
I understand that, but there's an injunction order in place. And
Well, I
to
think
me,
it's just
bond
a
is
no contact order, not an injunction. It's just no contact from the misdemeanor offense.
right. There's a no contact order in place. And the purpose of bond is to secure the appearance of the defendant at his proceedings. And the defendant has showed an inability to comply with prior orders. And so there's a concern in that regard. So I'm going to revoke bond in case number 2021 MM 9132.
And how much?
If you'd like to take that up with the division judge, you can file a motion to that effect, sir.
Sir.
And bond will be set. On case 2021 MM 9132, he was on PTR, is that right? With no bond? Or, okay. Okay. I'll set a bond at $500.
On the new case?
On the new case, the bond's $1,000.
Okay.
I'll set a bond on the 2021 MM 9132 at $500.
Thank you, Judge.
Thank you, sir.
Just a-
Anything further?
No, Your Honor, you may have just a moment with the client.
You may, yeah. Yes.
Take this paper with you. That's all. That's need for my, okay?
Everybody clear with that one?
Yes, Your
Before we
Honor.
move on?
I'm sorry, was that PTR?
Yes.
Thank you.
Okay. Cedric Raheem Lee.
How you doing today?
Good afternoon, sir. I am appointing the public defender, the lawyer standing next to you, to represent you today. You're here on a charge of battery, domestic battery by strangulation, and a count for aggravated battery on a pregnant person. Court has reviewed the arrest affidavit and determined that there is probable cause. Court will set bond on count 1 at, yeah. Oh, I'm sorry. Good afternoon, ma'am. Can you
Good afternoon.
state your name?
Michelle Rodriguez.
Can you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I swear.
If Mr. Lee, is it Mr. Lee or Mr. Leah?
It's Lee.
Mr. Lee. If Mr. Lee is released, do you wish to have any contact with him?
Yes.
Okay. Do you have any concern for your safety if he was permitted to have contact with you?
No.
Would you hesitate at all to contact law enforcement if there's another incident between the two of you?
No.
Okay, something like this happened before, or is this the first time?
First time.
Okay. Any questions from state or defense?
No, Your Honor.
Okay, the court's going to set bond on count 1 at $2,500 and count 2 at $2,500. As a condition, sir, you're not to have any hostile contact with the alleged victim. That means you can have contact, but you can't have any hostile contact. If you as much as raise your voice, that's potentially a violation of the terms of your release, and you could be back before the court waiting in jail before you have trial on your charge. Do you understand that?
Yes, sir.
Okay. Anything further from the state?
No, Your Honor.
Vince?
No, Your Honor.
Okay, thank you, sir. Best of luck to you. Best of luck.
Thank you.
Jamar Logan. Good afternoon, sir. I'm appointing the public defender to represent you. You are here on 2 cases. The first one is a charge of criminal mischief. I've reviewed the arrest affidavit and determined that there is probable cause. Court is going to set bond at $500 on this charge. You're not, as a condition, you're not to return to the scene of the alleged incident. Was he living there?
No, Your Honor, it's a hotel.
Right, but I didn't know if he has any personal belongings or anything.
Yes, he will need a one-time return to collect those belongings.
Okay. Court will permit a one-time return to the location to recover any personal belongings under the supervision of law enforcement. On your next case, you have a charge of battery, domestic violence. Court has reviewed the arrest affidavit and determined that there is probable cause for the charge. Court will set bond at $2,000. As a condition, sir, you're not to have any contact whatsoever with the alleged victim. Do you understand that?
Yes, sir.
Okay.
Your
Anything?
Honor, defense would ask for reduced bonds in the amount of, really as low as the court's willing to go. Mr. Logan lives out of state, so we're gonna also ask for the ability to leave the state of Florida. He promises to return for all future court dates, and he's telling me that because he lives out of state, he's gonna have to pay cash instead of surety, so we were asking for the lowest bond that the court's willing to do. Otherwise, it's the equivalent of no bond.
Any position from the state?
Sign it.
The state would not object to reduced,
Okay.
but not,
Court will set bond at $500 with the same condition, no contact.
On each,
I'm sorry?
500 on each case.
Correct. 500 on each case. He will be permitted to leave. It's critical, sir, that you be present for your court hearings. Do you understand that?
Sir.
Okay. Where is he going? Where out of state?
He lives in New York.
Okay. So avoid further trouble and potentially sitting in jail until your trial is held. It's critical that you show up. You understand that?
Sir.
Okay. Thank you. Best of luck, sir.
All I gotta.
Your Honor, while he's still here, since he is out of state, could we verify his address?
Okay. Can we have an address for you, sir, or we can do a change of address? Do you have a copy of the form? Oh, was there one on there? There's an address on the application.
Correct. I just wanted to verify that it was the
Okay.
correct address.
Sir, is your address? Where is it?
I miss
433 Valley Drive, Syracuse?
Yes, sir.
Okay,
Perfect. Thank you.
okay, thank you.
Thank you, Your Honor.
Carlos McCumphrey. Good afternoon, sir. I'm appointing the public defender to represent you.
Sir.
Sir, you're here on a charge of aggravated battery with a deadly weapon. The court has reviewed the arrest affidavit and determined that there is probable cause for the charge. Court will set bond at $2,500. As a condition, sir, you're not to have any contact with the alleged victim.
Go ahead, Your Honor. Sorry.
As a condition, you're not to have any contact with the alleged victim. You're not to have any weapons or firearms. Do you understand that?
Yes, sir.
Okay, anything from the state?
No, Your Honor.
Defense?
Your Honor, we would ask for a reduced bond. Mr. McHumphrey only supports himself with limited financial means, as you can see from the information sheet. He's working, between Taco Bell and then previously at the Dollar General, so it's a limited means situation. He has no other contacts, nobody else to help support him. We would also ask that if the court is more comfortable for the safety of the community and flight risk, that you put him on PTR.
Qualify? Any position from the state?
State would object to a reduced bond.
Yeah, the court's going to keep bond at $2,500, no contact, no weapons. Do they live together?
No, Your Honor.
Okay. Thank you, sir. Best of luck to you. Zabian Owens.
Yes, sir. How you doing?
Good. How are you, sir?
Doing pretty good.
Okay, you're here on a charge of domestic battery. I'm appointing the public defender to represent you. I've reviewed the arrest affidavit and determined that there is probable cause for the charge. With bond? Yeah. The court will order pretrial release with a bond of $2,500. As a condition, sir, you're not to have any contact with the alleged victim. Do you understand that?
Yes, sir.
Do you live with the victim?
No, sir.
Okay. You're to maintain separate residences. Anything further from the state?
No, Your Honor.
Defense?
Your Honor, defense would ask for a reduced bond of $1,000.
I'll deny that. Best of luck, sir. Heather Michelle Paris. Good afternoon. You are here, ma'am, on a charge of aggravated battery with a deadly weapon. I'm appointing the public defender to represent you. I've reviewed the arrest affidavit and determined that there is probable cause. Court's going to set bond at $1,000. As a condition of bond, you are not to have any contact with the alleged victim. Do you reside with the victim?
No.
Okay. You are also not to have any alcohol.
Okay.
You understand that?
Understand.
Okay. Anything from the state?
No, Your Honor.
Defense?
No, Your Honor.
Best of luck, ma'am. 1,000. Jason Parker.
Sir?
Good afternoon. Okay, sir, I'm appointing the public defender to represent you. You're here on a charge of battery, domestic battery by strangulation. There's actually 2 cases for him, is that right?
It appears so, Your Honor. That's what I've got.
1 case, 2 charges? Okay, I have 2 arrest affidavits, but I think that's right. So you're here on 2 charges, one charge, domestic battery by strangulation, and 1 charge battery. Court's reviewed the arrest affidavit and determined that there is probable cause for the charge. Court will set bond at $3,000 on the domestic battery by strangulation count, $1,000 on the battery domestic violence count. As a condition, with PTR, as a condition, sir, you're not to have any contact with the alleged victim. You understand that? And you're also not to have any alcohol. Anything further from the state?
No, Your Honor.
Defense?
Your Honor, I just want to make sure that he's allowed to return to, that he's allowed to go out of county. He lives in Brevard County.
He will be permitted to go to Brevard County.
Sorry?
You're permitted to go to Brevard County. It's critical, of course, that you show up for all of your court proceedings. You understand that?
Okay, I'm okay to go back. That's where I work at. I'm self-employed, independent person.
You can talk to your lawyer about that, but if you post a bond, then likely.
Okay.
Best of luck, sir.
Thank you.
Thank you, Your Honor.
doing? We need a break?
Whenever you're ready.
No PTO. Okay, Jeffrey Reynolds.
Yes, sir.
Okay, sir, I'm appointing the public defender to represent you. Okay, thanks. Just a second, I need to check something with this one. Okay, I don't have, so on the arrest affidavit I have for this, there's a reference to a prior report, original report in case number 2109, 21-094549, but there's no indication in the arrest affidavit as to what that report included. So I don't have any facts in this affidavit regarding the 3 charges of battery, committing domestic battery, battery domestic, and false imprisonment. Am I missing something on that, State?
No, Your Honor, I have the same, and the state would request a 24-hour reset just to be able to contact the officer and kind of figure out what's missing here.
Yeah, the court's inclined to grant that request. Anything from the defense?
No, Your Honor, I have the exact same information.
Okay. The court will reset this for tomorrow. Thank you, sir. Ma'am, this is going to be reset for tomorrow.
Is there a specific time?
Approximately.
Approximately what time?
I would call it like 9 o'clock in the morning.
Okay. Okay.
Yeah. That's how we originally had it. Yeah. Okay. We're good. Tomorrow. At the request of the state, 24-hour reset to get more information in the affidavit. We'll do this one, and then we'll go to. Do you have it? Just so everybody knows, the sign language interpreter is available, so we'll call that next after this case. James Edward Walker.
Yes, sir.
Good afternoon, sir. I'm appointing a public defender to represent you. You're here on a 1-count battery and another count for aggravated battery. It's great bodily harm. Court has reviewed the arrest affidavit and determined that there is probable cause for the charges. Court will set bond on count 1 at $1,000 and on count 2 at $2,000. As a condition, sir, of bond, you're not to have any contact with the alleged victim. Do you understand that?
Sir.
Do you reside? Do you live with the alleged victim? Okay. You're to maintain separate residences from the alleged victim. I will allow you to return to the residence one time under the supervision of law enforcement to recover any personal belongings. Okay? Anything further from the state?
No, Your Honor.
Defense?
$300.
Thank you, Your Honor.
Thank you. Okay, Jonathan Morales. Is it up there?
I don't know where the case is.
Maybe it's this one. Just share screen, join WebEx. Where are they? Where are they on? Is that a touch screen? Does anybody have any insights? How we get the sign language interpreter up there? If I click interpreter, you think that would do it, or that's going to call it? Anybody needs a break? Now would be a good time. Yeah. We'll take a brief recess for 5 minutes while we try to figure this out.
Hello, Cisco Unity Connection Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a
But I'm saying that
day in paradise. You're getting your interpreter. They're trying to get the sign language interpreter on the video. Yeah. Not as bad as I thought it was going to be this weekend. Mhm. Ortega said we were down to like 52 or something. Yeah. 68, something like that. Yeah. Do you read lips? You do. Okay.
Yeah, we're gonna have to move on. Sorry, sir.
I mean, he understands.
Yeah, we're gonna recall him.
Yeah, he understands. He was out there.
You can read lips.
Okay. Does he, well, I'll leave it to you if he requires the services. Okay, we're gonna call case Jonathan Morales. Good afternoon, sir. Can you understand what I'm saying? You can read my lips? Okay. I'm appointing the public defender to represent you, the lawyer standing next to you. Is my understanding that you do not require the services of an interpreter for this appearance?
Try my best to understand you, sir.
He said he could try his best to understand what you're saying.
Okay, if at any point you do not understand what's happening, tell your lawyer, tell me, okay?
Sir.
Okay, we're gonna proceed. You've been charged with 2 counts. 1 count, grand theft, 3rd-degree motor vehicle. 1 count, possession of drug paraphernalia. I've reviewed the arrest affidavit and determined that there is probable cause for the charges. Court will set bond on count 1 at $1,000 and count 2 at $500, 500. As a condition, sir, you're not to have any drugs or non-prescription medications. You understand that?
Yes, sir.
Okay. Anything further from the state?
Could you repeat the conditions? No drugs?
No drugs or non-prescription medications.
Thank you.
Defense?
Nothing from defense, Your Honor.
Thank you, sir. Best of luck.
You understand? You understand? Okay.
Lawrence Baker. Good afternoon, sir. I'm appointing the public defender, the lawyer standing next to you to represent you. You are here on a charge of battery, domestic violence, The court has reviewed the arrest affidavit and determined that there is probable cause for the arrest. Court is going to set bond at $500 with PTR, with pretrial release. And as a condition, sir, you're not to have any contact with the alleged victim.
He's going to need a one-time return at this time.
Okay. The court will allow a one-time return to the residence to recover any personal belongings under the supervision of law enforcement. Sir, if we don't have the alleged victim here, at this time, the court's ordering no contact. If you seek to modify the terms of your release, you can file a motion with the division judge, okay?
Thank you, Judge. If I may have just one moment.
You may.
Mr. Baker.
Anything from the state?
No, Your Honor.
Nothing else from defense.
Okay, thank you. Best of luck, sir. Okay, Andrea Brannigan.
Your Honor, she doesn't hear very well, so if you could just make sure that we speak up for Ms. Brannigan.
We most certainly will. If at any point you do not understand what's going on, let me know or let your lawyer know, okay? Do you understand that?
Yes, sir.
Okay. I'm appointing the public defender to represent you. You are here on 2 counts, 1 count battery, domestic violence, and 1 count violation of a domestic injunction. The court has reviewed the arrest affidavit and determined that there is probable cause for the charges. Court will set bond on okay, thank you. Court will order PTR with bond on count 1 at $1,000 and on count 2 $500. As a condition, you are to have no contact with the alleged victim. You are to comply with the domestic injunction that's in place. Do you understand that?
Yes, yes, sir.
Okay.
Who was the alleged?
Do they reside together?
Just 1 second, Your Honor. Beg the court's indulgence. I cannot take the report.
just so we're clear on the no contact, because the battery, the alleged victim is the son, and so it's no contact with the son. If you seek to change that or modify that, you can file a motion with the division judge. Is there proper, does the son live with the father?
Yes, sir, he's 18 or 19.
Okay. But who does he live with?
He lives with my husband.
Is he a minor?
No,
Okay, okay.
so am I still I'm allowed to contact my husband?
The injunction, ma'am, is, as I understand it, is with respect to your husband, and so you are to have no contact with him in accordance with the terms of the domestic injunction that's been entered.
So no contact with your husband, no contact with the son. Do you live with either of these people?
Yes, but I do have a place to go.
Okay, you need to maintain separate residences.
Yes, you're to maintain the separate residence. If you have items, I'm reluctant to order a one-time return. I suspect that's been done in the domestic.
I was living at home. It was altered, and I was living at home.
Okay, well, you might want to talk to your lawyer before you start.
The way that it was.
Your Honor, it sounds like the injunction or whatever is going on was modified at some point to no hostile contact, and then there was a violation of the no hostile contact. So everything that she owns is in the home, so she does need a one-time return with law enforcement supervision.
Understood. Court will permit a one-time return for purposes of recovering any personal belongings under the supervision of law enforcement. Anything further from the state?
No, Your Honor.
Defense?
No, Your Honor.
Best of luck, ma'am.
Next.
Okay. Adrian Coyne?
Refuse, Your Honor.
Refuse? Okay.
Refuse.
Defense reset?
Yes, Your Honor, 24-hour reset.
Okay, we'll reset Adrian Coyne for tomorrow. Caleb Quaresma. Good afternoon, sir.
Hi.
I am appointing the public defender to represent you. You are here, sir, on a charge of battery. The court has reviewed the arrest affidavit and determined that there is probable cause for the arrest. Court will set bond at $500. As a condition, you are not to have any contact with the alleged victim, and you are not to return to the scene of the incident. Do you understand that?
Yes, sir.
And we'll do that with PTR. Anything from the state?
No, Your Honor.
Defense?
One moment, Your Honor. Your Honor, the only thing that we would ask for is that he be allowed to leave the state as it is listed on his information sheet. He currently resides in California. He promises to return for all court dates.
Any issues with that?
No issues with that. Can we just verify his address that's listed on the affidavit?
Sure. So, sir, is your address 2125 Fernvale Drive, Stockton, California?
So I put that address because my lease is up in LA in 2 months, and I don't know where I'm moving yet. So I put that address because that's my mom's address, and I'll be going back there in like a month.
Okay, so
Do you want my current one in LA?
that would, I believe, be helpful.
Yeah, for sure.
If-
Do you want me to tell you right
Do
here?
you receive mail, let me ask, do you receive mail at your mother's address?
At both, yeah.
Okay.
She sent.
Is that sufficient for the state?
Sufficient.
Okay, it's critical, sir. You're going to be permitted to go home to California, but it's critical that you appear for any proceedings. Do you
I
understand?
plan to be back when you guys let me know. Yeah.
Okay. Best of luck, sir.
Thank you. Have a good day. Happy New Year.
Thank you, Your Honor.
Okay, David Gassett,
Yes, sir, Your Honor. Happy New Year's to you, sir.
Happy New Year, good afternoon. We're here on a charge of battery. I'm appointing the public defender to represent you. I have reviewed the arrest affidavit and determined that there is probable cause for the charge. Court's going to set bond. Does he qualify for PTR? Court will set bond, order PTR with bond of $750. As a condition, sir, you're not to have any contact with the alleged victim. Do you understand that?
Yes, Your Honor. Yes, we do.
Your Honor, they live together.
Okay. So the court's going to order separate residences at this time, and I will allow a one-time return to the residence to recover any personal belongings under the supervision of law enforcement.
Yes, Your Honor.
If for whatever reason you seek to modify the terms of your bond, you can file a motion with the division judge. Okay?
Yes, Your Honor.
Anything from the state?
No, Your Honor.
Defense?
No, Your Honor.
Thank you. Best of luck, sir.
Thank you, sir. You too. That's fine. Thank you so much. Have a blessed one.
Antonio Harrison.
Yes, sir.
Good afternoon, sir. I am appointing the public defender to represent you today.
Yes, sir.
You're here on a charge of battery, domestic violence. The court has reviewed the arrest affidavit and determined that there is probable cause. Court is going to set bond at $1,000. As a condition, you are not to have any contact with the alleged victim. Do you understand that? Do you reside together? Do you live in the same home with the?
Not anymore.
Okay, does he need a one-time return?
I got all that today. The same day the situation I was going to get my belongings, so I got them.
Okay, so you're to have no contact, maintain separate residences. Sir, you're also here, well, you also have an open case. Does the state have a position on the case number 2021 CF 13943?
State would request that bond be revoked in that case.
Defense want to be heard on that?
Defense would object to bond being revoked, and if Your Honor does revoke it, we would ask that you set it at a new amount with any other conditions that the court deems necessary.
Court's going to take no action on that case at this time. If you'd like to file a motion with the division judge on that.
Can the state inquire as to why?
No.
Okay.
You can file a motion. If you want to seek revocation, file a motion with the division judge.
Thank you.
Thank you.
Thank you, Your Honor.
Samantha Johnston. Good afternoon. I'm appointing the public defender to represent you this morning, afternoon, I should say. You're here on a charge of battery, domestic violence. The court's reviewed the arrest affidavit and determined that there is probable cause for the arrest. I see we have a witness present. Sir, can you state your name?
Quinzel Johnson.
Can you raise your right hand for me? You solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Are you the alleged victim in this case?
Yes.
Okay. If Ms. Johnston is released, do you wish to have any contact with her?
Yes, I'd love to.
Okay. Do you have any concern for your safety if she was permitted to have contact with you?
No, I never did.
Okay. Would you hesitate at all to contact law enforcement if there is a violent interaction between the two of you?
I never called the police, period.
I'm sorry, say that again?
No, I never called the police anyway.
You never called the police anyway, you said? Okay. But would you hesitate, well, my question is, would you have any hesitation to contact them if you felt concern for your safety?
No.
Okay. Okay, the court's gonna set bond at $500. I will order no hostile contact, which means the defendant will be permitted to have contact with the alleged victim, but it cannot be hostile in nature. So, ma'am, if you raise your voice, if you do anything that could be considered hostile, your conditions of release may be revoked and you may be sitting in jail. So it's critical that you follow that very closely, okay?
Yes, sir.
Okay. Anything further from the state?
No, Your Honor.
Defense?
Defense would inquire as to the APHIS ID hold and when that may be released.
I'm sorry, what?
An APHIS ID hold, will that be? Okay, do we expect it in the next 24 hours? We have no idea. Okay. Okay. Nothing further from the defense.
Okay, thank you. Best of luck, ma'am. Thank you, sir.
Okay.
Okay, Khalil Lalu.
It's medical, Your Honor. The victim is present.
Okay, would you like to reset?
No, Your Honor, I'd like to waive appearance.
Okay. Okay, the court is appointing the public defender to represent Mr. Lalu. Counsel has waived the appearance of Mr. Lalu at today's proceeding. Mr. Lalu's been charged with battery, domestic violence. Court has reviewed the arrest affidavit and determined that there is probable cause for the charge. Good afternoon, sir. Can you state your name?
Asher Query.
Can you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Are you the alleged victim in this case?
Yes, I am.
Okay. If Mr. Lalu is released, do you wish to have any contact with him?
Yes.
Okay. Do you have any concern whatsoever for your safety if you're permitted to have contact with him?
No, I don't.
Okay. Would you hesitate at all to contact law enforcement if there was another incident between the two of you?
There will be no hesitation.
Okay. Okay. Court is going to set bond at $500. As a condition of release, he is not to have any hostile contact with the alleged victim. Sir, that means he can have contact with you, but it cannot be hostile in nature. If he raises his voice, if he does anything that causes concern, he would be in violations of the terms of his bond and could be back in jail. Okay? Anything further on this case from the state?
No, Your Honor.
Defense?
No, Your Honor.
Thank you, sir. Lucas Xavier Lopez.
Yes, sir.
Good afternoon, sir.
Good afternoon.
You are here on a charge of battery, domestic violence. I'm going to appoint the public defender to represent you. I've reviewed the arrest affidavit and determined that there is probable cause for the charge. Court will set bond at $2,000. PTR with bond of $2,000. As a condition, sir, you're not to have any contact with the alleged victim. Do you understand that?
Sir.
Do you live with the alleged victim?
No, no, sir.
Okay. Anything from the state on this?
No, Your Honor.
Defense?
And the bond was 2,000.
Yes.
Nothing else from defense, Your Honor.
Thank you, sir. Best of luck to you.
Thank you. Have a good afternoon.
Correct, no contact. Kimberly Rivera?
Yes.
Good afternoon, ma'am. You're here on a charge of, oh, are we prepared to proceed?
Yes, Your Honor. Sorry.
No, that's okay. It's okay. It's just an initial appearance. We're gonna get through this.
Yep.
You're here on a charge of battery, domestic violence. I'm appointing the public defender to represent you today, okay? I have reviewed the arrest affidavit and determined that there is probable cause for the charge. We have a witness present. Sir, can you state your name?
Alfonso Bryant.
Mr. Bryant, can you raise your right hand, please?
Yes, sir.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. If Ms. Rivera is released, do you wish to have any contact with her?
Yes, I do.
Okay. Do you have any fear or concern for your safety if she's allowed to have contact with you?
No, sir.
Would you hesitate at all to contact law enforcement if there was another incident between the two of you?
Yes, sir. No, I wouldn't hesitate.
Okay. Okay, court's going to set bond at $500. As a condition of bond, the defendant is not to have any hostile contact with the alleged victim. That means she would be permitted to have contact, but it can't be hostile in nature. You can't be violent, you can't raise your voice, you have to be very careful to make sure that you're not violating the terms of your bond, okay? Also, as a condition of your bond, I'm gonna require no alcohol. So you're not to consume any alcohol. Okay, and this will be with PTR. Anything further from the state?
No, Your Honor.
Defense? No, Your Honor. Thank you. Best of luck to you.
Thank you.
Thank you, sir. Marissa, oh, sorry.
Go ahead.
Marissa Amelia Rodriguez.
Yes, Your Honor.
Good afternoon.
Good afternoon.
You're here on a charge of battery, domestic violence. I'm appointing the public defender today to represent you. I've reviewed the arrest affidavit and determined that there is probable cause for the charge. There's a witness present. Sir, can you state your name?
Stephen Wilson.
Good afternoon, sir. Can you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. Are you the alleged victim in this case?
Yes, Your Honor.
Okay. Do you have any, if Ms. Rodriguez is let out today or on bond at any point, do you wish to have any contact with her?
Yes, sir.
Okay. Do you have any fear for your own safety if you're allowed to have interactions with her?
No, sir.
Okay. Would you hesitate at all to contact law enforcement if there was another incident between the two of you?
No, Your Honor.
Okay. Okay. Court will set bond at $500. As a condition of bond, the defendant is to have no hostile contact with the alleged victim. That means you can have contact, but it can't be hostile in nature. So obviously no violence, clearly, but you can't raise your voice, can't have any contact that could be considered hostile. Otherwise, you risk running afoul of the conditions of your release, okay?
Yes, Your Honor.
And she qualifies for PTR, and it'll be with PTR. Anything further from the state?
No, Your Honor.
Defense?
No, Your Honor.
Okay, best of luck to you. Thank you. Glenn Ellis Smith. Good afternoon, sir.
How you doing?
Good. I'm appointing the public defender today to represent you. You're here on one count of battery and one count of criminal mischief. The court has reviewed the arrest affidavit and determined that there is probable cause for the charges. Court's going to set bond on count 1 at $1,000. That's the battery count, and on count 2, criminal mischief at $1,000. Thank you. With PTR, as a condition, the defendant's not to have any contact with the alleged victim. Do they reside together?
No.
Okay. Okay. No contact with the alleged victim, and no alcohol. No alcohol, sir. Do you understand that?
Yes, sir.
Okay. Anything further from the state?
No, Your Honor.
Defense?
Your Honor, defense would just ask for a reduced bond or PTR with ROR so that, because Mr. Smith is on Social Security disability, and as Your Honor is likely aware, Social Security disability doesn't pay a whole lot, and so his means of income are very limited.
Any position from the state?
The state wouldn't object to a reduced bond.
Okay. I'll reduce the criminal mischief bond to $250. So $1,000 on count one, $250 on the criminal mischief count.
Thank you, Your Honor.
Thank you.
Good luck to you, sir.
Stephen Vieira. Good afternoon, sir.
Afternoon.
You are here on a charge of battery domestic violence. I'm appointing the public defender to represent you. I've reviewed the arrest affidavit and determined that there is probable cause for the charge. I'm going to set bond at $250 with PTR, or PTR with bond of $250. Without a victim, I'm going to order no contact at this time with the alleged victim. Do they reside together?
Yes, they do, Your Honor.
Okay. I will permit a one-time return to the residence to recover any personal belongings. Sir, this is a DV case, but the allegations are not as egregious as some of the things that I see that we see frequently. So I've ordered no contact because we don't have a victim, and I'm not sure, the nature of whether or not she feels comfortable in your presence. But you can file a motion to modify that if you think that you'd like to change the terms of your release. Okay. Yes, separate residence, no contact. One-time return, $250 with PTR.
That was a $250 bond, correct?
$250.
Thank you.
Best of luck, sir.
Thank you, Your Honor.
Jarhia Warner.
Yes.
Good afternoon, ma'am. Is it Jarhia?
Maria.
Okay, sorry about that.
That's okay.
You're here, ma'am, on a charge of battery, domestic violence. The court is appointing the public defender to represent you. I've reviewed the arrest affidavit and determined that there is probable cause for the charge. Court's going to set bond at $500. As a condition of your bond, you're not to have any contact with the alleged victim. You understand that? That means no emails, no text messages, nothing of that nature, okay? Do you live with the alleged victim?
No, they don't live together, Your Honor. And there will be no issue with no contact.
Okay. Anything further from the state?
State would request that bond in the violation of probation for battery be revoked.
Do you have any idea what the nature of the alleged violation of probation? Is it a failure to appear, or?
If you give me one moment, I'll look. –
Your Honor, the case that I show,
20,
2836,
that's the one, yep. 21 MM,
not even
2830.
a violation of probation affidavit in the clerk's site. The last document that was filed was an order allowing withdrawal by the PD's office on 12/28. There's a violation of probation set, but there's no affidavit.
Anything further?
I have the same. Yep.
Okay, yeah, I'm not inclined to take action on case 2021 MM 2836 at this time. Best of luck, ma'am. Best of luck, ma'am.
Oh, God.
Michael Bennett?
That is not Mr. Minute.
Okay. Oh, did I miss one? Kamara Amadou? Okay. Good afternoon, sir.
Good afternoon, Your Honor.
Counsel, you need a second?
Nope, I got it here.
Sir, I'm appointing the public defender to represent you. You're here on 4 counts, 1 count of battery, committing domestic battery by strangulation, 1 count false imprisonment, 1 count aggravated assault, and a count of battery, dating violence. The court has reviewed the arrest affidavit. And determined that there is probable cause for the charges. Court's going to set bond on. Oh, I'm sorry. Good afternoon, ma'am. Can you please state your name?
Brandy Parker.
Can you raise your right hand for me? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. If Mr. Amadou is released, do you wish to have any contact with him?
Yes.
Okay. Do you have any concern for your safety if you're permitted to interact with the defendant?
No.
Okay. Has something like this happened before?
No.
Okay. Would you have any hesitation to contact law enforcement
No.
if something were to happen again?
No.
Okay. State, you want to inquire?
No, Your Honor.
Defense?
No questions for this witness.
Okay. Okay, court's going to set bond on count 1 at $2,500. Count 2, $500. Count 3, $500. Count 4, $500. As a condition, sir, you're not to have any hostile contact with the alleged victim. That means you can have contact, but it can't be of a hostile nature. You can't yell, you can't scream, you can't do anything that might suggest you're in violation of the terms of your release. Do you understand that?
Yes, Your Honor.
Okay. Anything further from state?
Your Honor, I apologize. My affidavit only has 1 charge, battery on a law enforcement officer. Would you mind repeating?
For Kamara Amadou?
Oh, this is Kamara Amadou? I apologize.
That's okay. I called Michael Bennett, but he's a reset from yesterday. Mr. Amadou is.
Okay. I apologize.
That's okay.
Your Honor?
Yes.
Your Honor, we would just ask for a reduced bond in the amount of account 1 for $2,500. You could reduce that to $1,000. Mr. Kamara has missed work, and he's not going to be able to afford that. It's going to cause him to miss even more work.
Any position from the state?
State wouldn't object to reduced bond.
Court will reduce the bond to $1,500. $1,500 on count 1, $500 for the remaining 3 counts. No hostile contact. Anything further?
No, nothing further, Your Honor. Thank you.
Best of luck to you. Thank you, ma'am.
So, Your Honor, are we on resets or are we back on the?
I'm back to Michael Lee Bennett unless.
Okay.
It's just that the victim was present. that's all.
Okay.
Thank you. Michael Bennett.
Yes, Your Honor.
Good afternoon, sir.
Good afternoon to you.
Okay, sir, you are here on a charge of battery on a law enforcement officer. I've reviewed, let me first appoint the public defender to represent you. I've reviewed the arrest affidavit and determined that there is probable cause for the arrest. Court's going to set bond at $500. Anything from the state?
No, Your Honor.
Defense?
Nothing else, Your Honor.
Okay, best of luck, sir. Jenna Kachiapudi. Like to reset or?
Or reset, Your Honor.
Okay, we'll reset for tomorrow. Julio Madison Castrofibus. Good afternoon, sir. Are you Mr. Castrofibus? Is that?
Yes.
Okay. I'm appointing the public defender to represent you this afternoon. You're here on a charge of grand theft motor vehicle. Court has reviewed the arrest affidavit and determined that there is probable cause. Court will set bond at $1,000. Anything from the state?
No, Your Honor.
Nope,
Defense?
nothing else, Your Honor.
Okay. Thank you, sir.
Sir.
Joshua Claveri.
Bonded, Your Honor.
Okay. Mario Dwayne Edwards. Good afternoon, sir.
Good afternoon, sir.
Okay, sir, you're here on a charge of aggravated assault with a deadly weapon. I'm going to appoint the public defender to represent you. I reviewed the arrest affidavit and determined that there is probable cause for the arrest. Court's going to set bond at $1,500, $1,500. As a condition, sir, you're not to have any contact with the alleged victim. You understand that?
Yes, sir.
Anything further from the state?
One moment. No, Your Honor.
Defense?
No, Your Honor. May I have a moment?
You may.
Nothing else, Your Honor.
Best of luck, sir.
Yes, sir. Thank you.
Isanju Omawale.
Bonded, Your Honor.
Jarrell Pizarro.
Bonded.
Donald John Richard.
Refused, Your Honor.
24-hour reset, Your Honor.
Okay, we'll reset Mr. Richard for tomorrow. Javier Rodriguez.
Your Honor.
Good afternoon, sir. I am appointing the public defender to represent you today. You are here on 4 counts of possession of drug equipment, 1 count of trafficking heroin, 1 count of distribution narcotics, 1 count of, or 1, 2, 16 counts of possession of a controlled substance without a prescription, 1 count of trafficking in oxycodone, and 1 count of possession of controlled substance without prescription. Should say another count of possession of controlled substance without prescription. The court has reviewed the arrest affidavit and determined that there is probable cause. Court will set bond on count 1 at $100, count 2, $100, count 3, $100, count 4, $100, count 5, $10,000, count 6, $1,000, count 7, $500, count 8, $500, count 9, $500, count 10, $500, count 11, 12, 13, 14, 15, 16, 17, 18, 19, all the way through 22, $500. Everybody understand that? Each, correct. On count 23, $10,000. Count 24, $500. As a condition, sir, you're not to have any drugs or non-prescription medications. Anything from the state?
No, Your Honor.
Defense?
Your Honor, may I briefly? Your Honor, Mr. Rodriguez has been a nurse for the last 10 years. Apparently, this is obviously something that we don't want to get into today. However, he does need to return to work. He is interested in substance abuse counseling. He understands the nature of these charges, so he's asking for a reduction so that he can get back to working and start working on getting these issues under control. So we would ask for a reduction at least to counts 5 and 23.
Any position from the state?
State would object.
The court's going to decline that at this time, sir. You always have the opportunity to file a motion with the division judge to try to modify the terms, okay? And issues regarding treatment, issues regarding those types of issues are for another day. So you'll want to speak with your lawyer about that, okay?
Yes, Your Honor.
Best of luck, sir.
Your Honor, just briefly, since it does appear that the defendant lives out of state, do we want to address whether he can leave the state?
Do you reside out of state, sir?
Yes, Your Honor. I live in Thomasville, Georgia, but I work in Tallahassee, Florida.
Okay. Does the state have, what's the travel time from did you say Thomasville?
Yes, sir. It's 45 minutes.
Okay. To Tallahassee?
Yes, sir.
Do you have a position on that?
It's faster than I thought it would be. No position.
Okay. He'll be permitted to return home if he bonds out. Obviously, sir, you understand that it's critical that you appear for all of your court proceedings, okay?
Sir.
Thank you, sir. Okay, Cecil Patrick Simmons Jr.
Yes, sir.
Good afternoon, sir.
Good afternoon.
I am appointing the public defender to represent you.
Good, how are you?
I have, you're here on a warrant arrest where probable cause was found for charges of fleeing, attempting to elude police officer, reckless driving, and driving with a suspended and revoked license.
The disorderly conduct was yesterday. The other three, he hadn't been served the warrant until today.
I think that's right. We had him here for disorderly conduct. Okay. Bond is set on count one, fleeing, attempting, $2,500. Count two, $250. Count three, $250.
Your Honor, defense would ask for a reduction in bond on the $2,500, count one. This is something that Mr. Simmons didn't know about until yesterday, and so that's a lot of money, along with the disorderly conduct that he has already sat for. He promises to return. He says that he has a driver's license. That gets into the details of the case, but
Any position for the state?
State wouldn't object to a minor reduction in bond.
Okay. I'll make it 1,000.
thank you, Your Honor. Are there any other conditions?
No. No driving without a suspended license.
Oh, I have a license. That's this whole.
You'll deal with it later.
Thank you.
Have a good day. Bye-bye. Thank you, Your Honor.
Dominic Tetty,
Hospital, Your Honor.
would you like to reset or waive?
Reset, Your Honor.
Reset for tomorrow. Olga Rose Valentine. Good afternoon, ma'am. I'm appointing the public defender to represent you today. You're here on one charge of possession of cocaine, one charge of possession of drug paraphernalia. Court has reviewed the arrest affidavit and determined that there is probable cause for the charges. Court will set bond on count one at $500. Count two, $250. As a condition, you're not to have any drugs or non-prescription medications. Does the state have any position on the open cases?
Yes, Your Honor. The state would request that bond be revoked in the other possession case, 21 CF.
21 CF 12069.
Yes, Your Honor.
And what about the driving while suspended with knowledge and DUI cases?
Yes, well, I suspect defense counsel is going to object, and I would at least like bond to be revoked in that case since the charges are very similar.
Any position?
Yes, Your Honor. Defense objects to a revocation in any and all of the other open pending cases. Your Honor, if you are so inclined to revoke bond, we ask that you reset it for another amount and allow her to get out. She does have children to take care of and get home to, and we don't want to put those children in that position.
Okay. Court's going to revoke bond in case 2021 CF 12069. State of a position on changing bond amounts, or are you requesting zero?
Due to the fact that one of them was a DUI, state would request at least a reset in the bond amount for the DUI. And state has no position on the Dwellis charge.
You said no position on the possession chart case?
On the Dwellis 21 CT 6144.
Okay, but did you have a position on bond on the possession cases? Are you requesting a zero bond in that case? Revoke, and is that zero? Okay, yeah, that's what the court's going to do. The court's going to revoke bond in 2021 CF 012069 and set bond at zero. I'm not going to take any action at this time on the other two open cases. Best of luck, ma'am. Malik Nathaniel Willis.
Greetings.
Good afternoon, sir.
How you doing today?
I'm appointing the public defender to represent you today.
Yes, sir.
You're here on a charge, 1 count aggravated assault with a firearm, and 1 count of carrying a concealed firearm unlicensed. The court has reviewed the. Do you have a?
Continue, Your Honor.
Court's reviewed the arrest affidavit and determined that there is probable cause for the charges. Court's going to set bond on count 1 at $1,500. Count 2, $500. As a condition, sir, you're not to have any weapons or firearms. And that'll be with PTR. Anything from the state?
No, Your Honor.
Defense?
Your Honor, Mr. Willis has never been in trouble before. He was apologizing to me for being here, when Your Honor thought we were interrupted. We would just ask for a reduced bond on count 1 to $1,000 so that it's as low as possible. And Mr. Willis, again, apologizes to the court that he is here, and I don't think that we'll have an issue.
Anything from the state on reduced bond?
State doesn't object to a reduced bond of 1,000.
Okay. Court will set bond at $1,000 on count 1, $500 on count 2.
Thank you, Your Honor. Can I have the court's indulgence so I can explain?
Of course. Best of luck, sir.
Thank you.
Sure. No problem.
Should we take a
Sure. Comfort break?
comfort break in a couple minutes?
We can do it. Do you want to get through him and then we'll take them after him? Okay. Good afternoon, sir. Michael Anthony Graham Jr.? Yes. Okay. I'm appointing the public defender to represent you today. Sir, you're here on a charge of operating a motor vehicle without a valid license. I've reviewed the affidavit, determined that there is probable cause. I'm inclined to ROR. State, do you have a position on that?
State has no objection to ROR.
Okay. Sir, you'll be released on your own recognizance under the condition that you do not drive without a driver's license, okay? You understand that? You understand that it's critical that you show up for every court proceeding that you have? Okay. Best of luck to you, sir.
Thank you, Your Honor.
Okay, we'll be in recess for 5 minutes. Is that good?
Oh my gosh.
Okay, we're back on the record. And our next case is Gerald Keith Nelson.
Bonded, Your Honor.
Bonded, okay. Quincy Wilson. Good afternoon, sir. So you're here on a bench warrant for failure to appear. I'm appointing the public defender to represent you. Bond was set at $4,000 where it's going to remain. So court will set it $4,000.
Your Honor, Mr. Wilson would ask for a reduction that's a little more expensive than he is able to afford. And he says he turned himself in.
Any position from the state?
State would object, given that he has 6 prior failure to appears.
Yeah, the court's going to keep bond at $4,000. Best of luck, sir. Jimmy Cedeno Barcia. Okay. Juan Cedeno Barcia. Kenneth Frost. Good afternoon, sir. I am appointing the public defender to represent you today. You're here on 3 counts of battery. The court has reviewed the arrest affidavit and determined that there is probable cause for the charges. Court's going to set bond on count 1, $250, count 2, $250, count 3, $250. As a condition, sir, you're not to have any contact with the alleged victim. Do you understand that? And you're also not to return to the scene of the incident. Anything from the state?
No, Your Honor.
Defense?
No, nothing from the defense, Your Honor. Thank you.
Okay, thank you, sir. Best of luck. Jordan Reed Hinkle.
Sir.
Good afternoon, sir. Okay, sir, you're here on a charge of petty theft with a prior theft conviction. I am appointing the public defender to represent you. I've reviewed the affidavit and determined that there is probable cause. Court will set bond at $500. And you're not to return to the scene of the alleged crime. Anything from the state?
State would request that bond be revoked in 21 MM 8122.
Defense?
Your Honor, if you're so inclined to revoke bond in 21 MM 8122, we would just ask that you reset it.
Court will revoke bond in case 2021 MM 8122 and set it 0. Best of luck, sir. Cody Christopher Siegfried.
Here you go, Your Honor.
Do you want
24-hour reset, Your Honor.
We'll reset for tomorrow. Aaron Alexander Williams. Good afternoon, sir. Okay, sir, you're here on a charge of trespassing on property after warning. I'm appointing the public defender to represent you. Court's inclined to ROR. Any objection from the state?
No objection.
Okay, sir, you'll be released on your own recognizance. You're not to return to the scene of the trespass. Do you understand that? You understand it's critical that you show up for all your court hearings. Do you understand that?
I understand.
Okay, best of luck, sir. Okay, James Terrence Lindsay.
Yes, Your Honor.
Lindsley. Good afternoon, sir. You're here on an out-of-county warrant. No bond was set, so you're going to be transferred, okay?
Do you know how long they have to come get me, or?
I couldn't tell you that. I don't know if anybody in here has any insights on that. Okay. You'll be transferred hopefully as soon as possible. Thank you, sir. Jose Alberto Sanchez. Good afternoon, sir. You are also here on an out-of-county warrant. You're going to be transferred. Okay? You're going to be held and transferred so that you can appear before the county that the warrant was issued in, okay?
Yep. I don't know. That's it.
Thank you, sir. Ada Figueroa.
Yes.
Good afternoon.
Good afternoon, Judge.
Okay, I am appointing the public defender to represent you, the lawyer standing next to you. You're here, ma'am, on one count of destruction of evidence, one count of possession of drug paraphernalia. Court has reviewed the affidavit and determined that there is probable cause for those charges. Court is going to set a bond, $250 on the destruction of evidence count and $100 on the possession of drug paraphernalia count. As a condition, you're not to have any drugs or non-prescription medications. Anything from the state?
No, Your Honor.
Defense?
No, Your Honor.
Okay. Best of luck, ma'am. Elijah Terrell Reed.
Medical, Your Honor.
Your Honor, at this time, defense would like to waive Mr. Reed's appearance. This has already been reset before.
Okay. The court is going to appoint the public defender to represent Mr. Reed. Counsel has waived the appearance of Mr. Reed at the initial appearance. He's been charged with aggravated assault with a deadly weapon without intent to kill. The court reviewed the arrest affidavit and determined that there is probable cause for the charge. Bond will be set $1,000. He is to have no contact with the alleged victim, and he's not to have any weapons or firearms. Anything from the state?
No, Your Honor.
Vince?
No, Your Honor.
Thank you.
Your Honor.
Vincent Lamar Williams. Booking number is medical?
Your Honor, I believe that this one's been reset a few times now, and I feel that defense's position is that we have to deal with this instead of just keep kicking it down the road.
Okay. Would you like,
Several of his charges have no bond as of right now.
would you like to waive his appearance?
Mr. Williams' appearance.
Okay, the court is appointing the public defender to represent Mr. Williams. Counsel has waived his appearance at the initial appearance. He's been charged with grand theft, 3rd degree. Court has reviewed the affidavit and determined that there is probable cause for the charge. Court is going to set a bond at $1,000 with no return to the scene of the incident, of the alleged crime. Anything from the state?
No, Your Honor.
Defense?
No, Your Honor. Is that the only one we're going to deal with?
The only one I have for Mr. Williams. Do we have any other? No.
I think, do you mean because he has several without bond?
He has several without. We'll just let the division judge take care of that.
Yes. Okay, Jonathan Blount? Blount? Good afternoon, sir. Okay, sir, you're here on a charge of open container. Court's appointing the public defender today. Court has reviewed the affidavit and finds probable cause for the arrest. Court is inclined to ROR. Any objection for the state?
State doesn't object to an ROR, but we would ask that bond be revoked in the felony charge.
Defense would object to the revocation and ask that if the court is inclined to revoke, that they reset the bond.
Okay. Court's gonna ROR him on the open container charge. Gonna revoke bond in case 2021 CF 13333. And we'll set it at 0. Best of luck to you, sir.
Thank you so much, Your Grace.
Sebastian Fernandez.
Yes, sir.
Good afternoon, sir.
Afternoon, sir.
I am appointing the public defender to represent you today.
Yes, sir.
You're here on a charge of disorderly conduct. Court has reviewed the affidavit and finds that there is probable cause for the charge. Court's inclined to release him on his own recognizance. Any objection from state?
No, Your Honor.
Okay. Sir, you'll be released today, but it's critical that you show up for all of your court proceedings, okay?
Yes, sir. ROR. Oh. Go Army.
Thank you, Your Honor.
John Kalin. Good afternoon, sir. Are you Mr. Kalin?
Yes, sir.
Okay. Sir, I am appointing the public defender to represent you today. You're here on a charge of disorderly conduct. I've reviewed the affidavit and determined that there is probable cause for that charge. Court's inclined to ROR. Any objection?
No objection.
So you're going to be released on your own recognizance, but it's critical that you show up for all of your court proceedings, okay?
Yes, sir.
Best of luck to you.
Good day.
Terrence Lee.
Yes, sir.
Good afternoon, sir. You're here on a charge of disorderly conduct. Court is appointing the public defender to represent you. Court has reviewed the affidavit and determined that there is probable cause for the charge. You're going to be released on your own recognizance today, but it's critical that you show up for all of your court proceedings, okay?
Yes, sir.
Okay. Anything further? Okay. Thank you, sir. And our last case is Tuan Nguyen.
Yes, sir.
Is that correct?
Yes, sir. Yes.
Okay. Good afternoon, sir. You're here on a charge of disorderly conduct. I am appointing the public defender to represent you. I've reviewed the affidavit and determined that there is probable cause for the charge. I'm going to release you on your own recognizance today, meaning that you're free to go, but you have to arrive and show up for all of your court proceedings. Do you understand that?
Thank you, sir. Yes,
Okay.
understand that.
Best of luck to you.
Okay, thank you. Have a nice day, sir. Thank you.
Thank you. Are we all done? Okay, we're going to go off the record.